it has been argued that the UK intelligence sharing agreement with the US will be jeopardised if the UK asks not to receive evidence obtaining using torture. Does this suggest that ministers were reluctant to see such material but did not want to risk arguing with the Americans? Now, since you said just now that Lady Thatcher said under no circumstances are to use torture, presumably that one statement you've made blows a hole in the whole argument that we should be careful about using torture obtained information from the CIA.
I think what had happened was that the policy had changed since Lady Thatcher's day, and at the time I drafted the first telegram, which I told Mr. Sharma about, I didn't know the policy had changed since Lady Thatcher's day. But sadly, when you think about it, and if I may refer, for example, to the documents on waterboarding and other torture techniques which were released on the orders of President Obama in the United States recently, if we are continuing to, as we are, to receive all the intelligence reports put out by the CIA, then there's a huge amount of torture with which we are complicit. I was just seeing a little corner of it in Uzbekistan.
Did you accept the legal advice from Sir Michael Wood?
No, sir.
Sorry, I thought that was somebody else. I've done mine.
Are you finished?
I think I've finished. Except perhaps I would like to tease a bit more about this change of policy. It does seem very important that if Lady Thatcher says, no, you're not to accept the information, if Mr. Brown or John Major, or whoever the successor, or Mr. Blair, had said the same things, presumably the Americans would have reacted in the same way as they did to Mrs. Thatcher.
I don't know. I don't think that the particular material which was under consideration when we had the guidance from Number 10 that we don't look at anything that might come from torture, back at the time of the first Gulf crisis, I don't recall that was actually CIA material particularly. It may have come from another source. But certainly in terms of the change of policy, and I was told, because I was very surprised, because I'd been on Foreign Office human rights training courses, and it had been understood that we had the fact that we had a policy of not accepting intelligence from torture was, if you like, what you would expect the position to be. So when in early March 2003, at this meeting in London, I was told it was now policy that we do accept intelligence from torture, that may have been obtained by torture, or quite certainly has been obtained by torture. I was very surprised, and I was told directly that had been agreed and had the authority of the Secretary of State, that this came from Jack Straw. And I was told that he had discussed it at a meeting with Sir Richard Dearlove, and that whether there were other meetings as well that I wasn't being told about, I don't know. But I know for sure, because I was querying it. I was saying, well, this is not what we do. This is not our policy. And I was told directly, yes, this is the policy. You are a civil servant. You must follow it. And we will accept intelligence that has come from torture, as long as we don't do the torture ourselves, and in accordance with the legal advice of Sir Michael Wood, which I was given on that occasion.
Was the policy of the previous government, Mrs. Thatcher government, written down in a document anywhere, set out in writing? Did you see anything like that, or were you just informed that this was how it was?
I think we were just informed this was how it was. I don't recall seeing a policy paper on the subject. But as I say, that policy was taught on Foreign Office human rights courses. There's no doubt about it.
Okay. Ed Timson.
You've touched on the legal advice from Sir Michael Wood, the senior legal advisor at the Foreign Office, and the answers that you've previously given seems to suggest that you don't agree with that advice, that the receipt or possession of information obtained under torture is not prohibited by UNCAT. Did you accept that legal advice? And if not, did you seek to challenge it?
Sir Michael Wood was the legal advisor, which is a formal title. He had many other legal advisors under him. There is no internal method of challenging, legally within government circles, challenging the legal advice of the Foreign Office legal advisor on a point of international law. I did, in the telegram which I have given the committee, which is my telegram of the 22nd of July 04, which was the last telegram of the 20-year career I sent before they sacked me, I did challenge Sir Michael Wood's legal advice. And I pointed out that he appeared to have not taken into account Article 4 of the Convention of Complicity and Torture. Now I'd like to say this. I presume that the committee are aware of the human rights situation in Uzbekistan and the record of that country for torture. I dealt with and investigated, my team investigated scores, if not hundreds, of cases of political arrest of dissidents in Uzbekistan. I never came across a single case in which torture was not credibly alleged. And I mean the most horrible forms of torture, which I don't believe in shock value, so I'm not going to enumerate, but the most horrible forms of torture imaginable were always used against dissidents under questioning in Uzbekistan. The United Nations, in early 2003, the United Nations Special Rapporteur on torture, Professor Theo van Boven, produced a official UN report where he said...
I think we're straying a bit beyond our terms of reference. I think we can take it as Uzbekistan for record.
Chair, I think Lord Lester would like to...
I ought to declare an interest because I was counsel, together with Sir Sam Silkin, the Attorney General, in the Irish State case, where we gave an undertaking to the European Court of Human Rights that the British government would never use torture or inhuman or degrading treatment again, following what had happened in Northern Ireland. In the documents that you were given, including Sir Michael Wood's advice, did you see anything to indicate that there is a positive obligation on the United Kingdom, positive obligation, to take steps to minimise the risks of torture? Did you ever see anything of that kind?
No, I was aware of that from my own reading of the UN Convention Against Torture, but nothing that was given to me in the context of all the discussions I had with the FCO on this matter would have indicated that. If I may just say, Mr. Chairman, the point I was making was that given that the United Nations said that torture was a routine investigative technique in Uzbekistan, we could be sure with almost 100% certainty that any piece of intelligence coming to us that came from an Uzbek interrogation was from torture. And when you are receiving, the case that I put to the FCO was when you are receiving these on a weekly basis, sometimes several a week, these intelligence reports from interrogations in which you know that torture is routinely used. If you keep getting them and keep getting them and keep using them, then you are without any doubt complicit in torture under Article 4 of the UN Convention. I have never met any international lawyer, and I've spoken to at least 30 or 40 on precisely this point. I have not met one international lawyer not in government employ who does not agree with that.
We'll be hearing from an eminent one after you, so we'll be asking him those sort of questions. Have you finished yet? Thanks. Evan.
It's fair to say there isn't